Personal liberty is a constitutional promise, but what happens when freedom is delayed even for a few hours? This documentary examines the Kiet and Inspector Muhamad Azamuddin, a High Court case asking one crucial question. When does lawful detention end? The applicants claim that the extra hours of detention violated Article 5 of the Federal Constitution.
Mr. Kong, I am Inspector Azamuddin from Brickfields Police. You are under arrest for cheating under Section 420 of the Penal Code.
Can I at least call my family or a lawyer?
You may make a phone call as allowed by law. For now, you will be placed in the lockup while we investigate.
On 12 June 2024, the applicants were arrested at Brickfields Police Station. Within 24 hours, they were brought before a magistrate for remand under Section 117 CPC as required by Article 5 Clause 4 and Section 28 of the CPC. We now go to the Magistrate Court on 13 of June 2024.
This is the police application for remand under Section 117 of the Criminal Procedure Code. Inspector, please explain your remand application.
Point Magistrate, the investigations have just begun.
Point Magistrate, remand under Section 117 of Criminal Procedure Code does not give an affirmative right to detain. The police must show why further custody is truly necessary. Article 5, Clause 4 of the Federal Constitution, a person arrested must be brought before a magistrate within 24 hours and cannot be detained longer without the magistrate's authority.
I am not satisfied that further detention is necessary. The remand application is refused. Inspector, why is there a second remand application?
Point Magistrate, further inquiries reveal more suspected victims. We need more time. We therefore request a further remand period under Section 117.
Point Magistrate, this is a repeat application without concrete justification. Section 117 Criminal Procedure Code requires real justification. Under Article 5, Clause 4, once they have been produced before a magistrate, they cannot be kept longer than reasonably necessary without a proper order. There is no sufficient basis for remand here.
I remain unconvinced. The second remand application is refused. The applicants are to be released.
All rise.
So, can I go home now? Yes, the court already recorded notice.
Despite the refusal on 13 June, the applicants were not released. They remained under arrest at the police station until about 7 p.m. and were then re-arrested. They were once again brought before the magistrate the next day, 14 June 2024, for a second remand application.
Seconds, minutes, hours, days, weeks, months, years.
The court said I am released. Why am I still being kept here? When can I leave?
There's still paperwork to settle. Please wait.
Tuan!
According to the facts before High Court, the magistrate ordered release late morning on 14 June 2024. However, the applicants only left around 6 to 7 p.m. No new remand order, no fresh arrest. They alleged this 8-hour delay was unlawful detention under Article 5 Clause 1 and Clause 4. They filed a habeas corpus application in the High Court seeking release and damages. We now move to the High Court.
This is a criminal application for a writ of habeas corpus in WA 5706 of 2024, arising from an investigation under Section 420 of the Penal Code. Federal Counsel, you have raised preliminary objections. Please proceed.
Much obliged to Young Arif, the affidavit was sworn by a family member, not the applicants themselves. Further, the applicants had already been released, making the application academic.
Young Arif, this habeas corpus application is brought under Article 5 of the Federal Constitution. As the applicants were still on remand, Section 367 of the Criminal Procedure Code permits a third party to file an affidavit on their behalf. Article 5, Clause 2 does not require the complaint to be made personally by the detainee, and in any event, the second applicant has seen affirmed the allegations by a further affidavit.
Silence in the court.
I know that a person on remand has limited communication, including under Section 28A, Subsection 2 of the Criminal Procedure Code. In such urgent circumstances, a next of kin may properly move the court on the detainee's behalf. With the subsequent affidavit filed by the second applicant confirming the matter, I am satisfied that the affidavits are properly before this court, and the preliminary objection is accordingly overruled. Counsel for the applicants, you may proceed.
Much obliged, Yang Arif. In essence, although the magistrate twice refused remand and ordered the applicants released around noon on 14 June 2024, they were only released at about 6 p.m. Under Article 5 of the Federal Constitution and Sections 28 and 117 of the Criminal Procedure Code, there was no lawful authority to detain them after remand was refused. The continued detention for about 8 hours was therefore unlawful and amounted to false imprisonment, for which the applicants seek appropriate relief, including damages and compensation.
Federal Counsel, your response?
Yang Arif, the respondents submit that although there were some delay following the magistrate's order, the applicants were released on 14 June 2024 and are no longer in detention. Habeas corpus addresses present detention. What the applicants now seek is damages, which belongs in civil court.
I have considered the affidavits and submission from both parties. While there is material alleging that the applicants were detained for about 8 hours after the magistrate had refused remand, habeas corpus is concerned with testing a present unlawful detention. As the applicants have already been released and now seek compensation for past detention involving disputed facts, the matter is more appropriately pursued by way of a civil action. The applicants are not without remedy, but this is not the proper forum to assess damages. Accordingly, the application for habeas corpus and the claim for damages are dismissed.
This case proves that remand powers under Section 117 CPC are limited and subject to judicial oversight. Police must act with caution once remand is refused. Even a short period of extra detention can have a serious legal consequences and may give rise to a civil claim despite a dismissed habeas corpus application. While such detention could support a civil claim for false imprisonment, habeas corpus is not the proper forum for assessing damages once the applicants are free. Thank you for watching Law MP4.
of criminal.
The affidavit was
Around noon on...
I don't even know. Wait, aku rasa aku tengah improv gila.
Aku terlupa my...
Bye, 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 hi.
And what are you, magistrate?
Magistrate.